Hello, and in this video I want to have a look at Caldwell recklessness. Now let's have a bit of a recap. So in order to establish a crime, we need the actus reus, which means the actual wrongful conduct, and the state of mind to be culpable, i.e. the mens rea. Now the most culpable type of mens rea is having the intention to commit the crime. One below that is recklessness, which is all about knowing a risk and taking it. So historically we had the Cunningham recklessness test, which you can see my video on, which essentially was a subjective test which asked the question, was the defendant aware of the risk, and if they were so, was the risk unjustified for them to take? And it was a subjective test, as we saw in cases like R. and Parker and R. and Stevenson. So what happened is we have the case of R. and Caldwell in 1981. Now, what happened was the defendant set fire to a hotel while drunk, and he was charged with criminal damage. Now, what happened is Lord Diplock took this opportunity with this case to create a new test for recklessness, an objective test for recklessness. So he said that the test that should be given to the jury was an objective one, which should ask, firstly, was the defendant doing an act which in fact creates an obvious risk? And this first limb about creating an obvious risk, later on in the same day when he does the case R and Lawrence, he changed it to creating an obvious and a serious risk, or a substantial risk. And this is just basically highlighting that this first limb is no longer subjective, it's objective. That was this risk which was obvious and serious, it should be obvious and serious to a reasonable person as opposed to the defendant, because he argued that it was too difficult for the jury to go inside of the minds of the defendant. And the second limb is that the defendant does the act when he is either A, not giving any thought to the possibility of there being a risk, so turning a blind eye to the risk, or has realized the risk but nonetheless gone ahead and still done it. And he followed that, as I said, the same day with R and Lawrence, where he said the idea of serious risk was added to obvious risk. Now, there are lots and lots of problems with this, and this is why this Caldwell test is no longer the present law, the current law we have. The first one is it just sort of confused things with the types of crimes. So there was only like criminal damage and two other types of crimes that would be covered by the Caldwell test, and then there was two crimes which were covered by the Cunningham test. It made things more difficult in the law to start with. And the second thing is it also led to something called the Caldwell lacuna. This is basically referring to the idea that the test was not exhaustive. So what do I mean by this? I mean that once we establish the first limb, that yes, this risk was obvious and it was serious to a reasonable person, there is no way for the defendant to get out of having a reckless mind unless they can basically say that they thought there was no risk, and it was or if they thought there was a risk, it was a negligible risk. Because if they didn't give any thought to it, then they would be being reckless, and if they did think that there was a risk, then they were being reckless. So the only way is for them to think about the risk and come to the wrongful conclusion that no such risk exists. And I think this was put in a case R and Reed, where it was made clear that this Caldwell lacuna did exist. There was a gap in the law. The test is not exhaustive. The next criticism is referring to the same thing. What about if the defendant thinks and misses the obvious risk? Again, we're talking about the lacuna here. And there's another problem, that who is this risk supposed to be obvious to? So Lord Diplock talks about the jury, because he wants to give the word an ordinary sense of its meaning. That's who he says that the risk should be obvious to. But is this fair? Because the law should only be criminalizing those people who are culpable, and a way of establishing culpability is not only the wrongful act, but we need a culpable state of mind. It's a principle of criminal law. The other principle of criminal law is that We try to minimize criminalization and maximize certainty within the law and autonomy within the law, and this goes against all the basic principles of criminal law. So a lot of people think, what was Lord Diplock actually thinking? What if the defendant thinks and sees the risks? Okay, so this is basically saying that the defendant, he realizes the risks, but in order to prevent a bigger harm happening, decides, oh, let me go ahead and do that, but he's just inadequate to do that. So, i.e., someone going to save someone's life by taking unjustified risk. This would be covered in the Cunningham test. It's not really covered in the Caldwell test, and it leads to a lot of unfairness and unjust outcomes. So, an example of this is in Elliot and C, 1953, a 14-year-old girl who had learning disabilities. She was out late at night and she was cold, she was hungry, and she goes into a shed and she lights a fire. And what happens is she ends up burning the shed down, so she's convicted. So then under this test, she was held convicted because the risk is obvious to a reasonable person. They don't even take into account that it was obvious to a person of her age. It was just an obvious risk to take. And yeah, so she's basically charged on there, and this caused a lot of people getting upset and angry because it wasn't fair for somebody like that who didn't even have the ability to think about the risks to be convicted of a criminal sanction. And remember, when we looked at the beginning of the distinguishing factors between criminal and civil proceedings, one of the key things with criminal convictions is it's much more serious and it has many more consequences. So this was even more of a problem. And also, Lord Diplock talks about addressing a problem that is hard for the juries to look inside the mind of the defendant. It wasn't even a problem at all, because till then everything was going smoothly. So really there was no need for this Caldwell test. I really dislike it. And then he ignores Parliament's intention. So you can see from the Hansard Law Commission report, all these different places, the whole idea of the Criminal Damage Act, I think 1971, was the idea to create a subjective test. The defendant's mind must be guilty in order to convict him or her. And yeah, finally, I'm just stressing again here that, just ignore the culpability aspect of criminal law, which is so important. Now, just before ending, I thought I'll say a few brief points. Why on earth did Lord Diplock do this then? Well, I think he was trying to attack this couldn't care less attitude that people just turn a blind eye to the risk. He wanted those people to still be found guilty. It was his attempt at giving the word recklessness an ordinary meaning. We don't even use recklessness in ordinary English, so I don't think that's possible for him to even make a statement like that. And he stated that consciously taking a risk was not necessarily more blameworthy than failing to give thought to any possibility of risk. So he was basically, again, talking about this couldn't care less attitude. He wanted more people to be found guilty of, to make the criminal legal system more tougher. And a positive, though, I thought, is there is a positive in the test, which is that in the case of minor crimes like speeding and stuff like that, it's hard to I know there's strict liability offences, but it's hard to try and find a guilty mind in those situations. And also, juries and magistrates, they tend to anyway just use a reasonable man test, so it's just kind of putting what was already happening in practice in the proper common law principles as a precedent. So anyway, I hope this video helped. I don't really like this Caldwell test because I think it's totally unfair, and this can be seen from the Elliot and C case, because the whole idea of the legal system, is to protect the vulnerable, to make just decisions, which this test did not do. And this is why it was so short-lived. So we'll see in my next video on present law that this all changed with the case of RNG. Thank you for watching.